morning, everyone, and welcome today to today's webinar, Tax Topics with Cooper Levenson. Thank you, everyone, for joining us. First, I'd like to give our appreciation to the attorneys and staff at Cooper Levenson. Thank you for agreeing to present today. We have a few administrative items before we start. First is the Q&A and the chat. If you have a question related to the content that we're presenting, you can go ahead and click the Q&A button on the bottom of your screen. There you'll be able to ask a question to the presenters. All the questions will be addressed at the end of each speaker's portion. If you have any technological issues, please use the chat on the right-hand side of your screen. You'll be able to send a message directly to me, and I'll be able to help address that issue with you. Finally, in order to receive credit for today's program, we'll be issuing a number of polls. So I will throw up a sample poll at this time, and you should see it pop over on your screen. The question will say, are you actively participating in today's program? And you'll be able to answer that question. If you do not see a poll, please make sure to just take note of the time that the poll is launched and send an email to education@njcpa.org at the conclusion of the program, letting us know you are having difficulty accessing any of the polls. I'll be leaving those polls up for quite some time, so you'll have some time to answer them. At this time, I'll end that sample poll. So again, I'd like to extend our appreciation to the attorneys at Cooper Levenson. At this time, I will turn it over to our first presenter, Lou Needleman. Go ahead, Lou.
Thank you, Ariana. This is a most challenging time, not only because we are at home or social distancing, but the technology of doing this seminar is equally challenging. So on behalf of the law firm, we appreciate your attendance. I hope everyone can, I'm anticipating everybody can see me and hear me. I am wearing headphones because my audio, I require this so I can hear everybody else. Okay, let me begin by telling you that I am a partner with the Cooper Levenson law firm, and my specialty is insurance coverage, claims, and litigation. And what I'd like to do is quote, this is illustrative only, but I'd like to quote from the King James Version of the Bible, and I'm sure Rob Salad is saying, where's he going? But if I can quote that, it says, quote, the Lord giveth and the Lord taketh away. I'm just using that as an example because in the insurance world, insurance companies also giveth and taketh away. And when I say that, what I'm saying is that when an insurance policy is issued to a business or to an individual, it usually is maybe a 16-page document which provides you with the insurance coverage that you have asked for and the insurance coverage for which you have paid. But there's also behind the 16-page document a 45-page document that takes away some of the insurance coverage that you have purchased. Before I tackle the COVID-19 interplay with insurance issues, what I'd like to do is just take a few minutes to talk about general insurance policy principles and how New Jersey courts interpret them. And then I'm going to circle back and I will relate this to COVID-19. And this language is language that you may be familiar with, but let's talk about policy endorsements. Insurance policy endorsements, they are riders or amendments to existing insurance policies, and endorsements change the terms of the original policy which affords you coverage. Endorsements can be issued at the beginning of a policy. They can be issued in the middle of the policy term or upon renewal. Next, I'm going to talk about ambiguities in insurance policies and how New Jersey courts deal with ambiguities in insurance policies. A New Jersey court will not manufacture ambiguities in an insurance policy. If an insurance policy language is clear and the meaning is understandable to a lay person, a court will leave it alone. However, if there is an ambiguity in an insurance policy where it's so confusing that the average policyholder cannot make out the boundaries of coverage, courts will intervene to interpret the policy. And these interpretations are generally in favor of the insured, the policyholder, and not the insurance company. And the reason is because in the legal realm, we call these contracts of adhesion. And that means that the policyholder, when you apply for insurance, really has no choice in the language that is put before them, the policy language. And the policy language is really a product of the insurance industry. So therefore, courts are liberal in interpreting any ambiguities in favor of the policyholder. Lastly, and this will segue into our COVID-19. There are also policy exclusions, and policy exclusions do just that. They exclude from insurance coverage that coverage which initially appears in the body of the policy. And since exclusions take away coverage from the policy holder, courts in New Jersey will narrowly interpret exclusions in favor of the policyholder and against the insurance company. So let's next talk about now COVID-19. COVID-19, we describe it as a pandemic, but it's also a plague for the economy and the restaurants and the businesses that rely upon the engine of a business in order to survive and to make a profit. In an insurance policy, there's what we call first-party claims and third-party claims. First-party claims in all insurance policies are claims that the policyholder, the insured, would assert against their own insurance company for claims that befall them and their business operation. That's what really we're going to discuss in COVID-19. Third-party claims are claims that are brought by third parties against a business or an individual. And an example would be if a patron of a bar claims that they contracted COVID-19 at the bar and they took ill, they would have a claim against the bar for their illness. I'm going to put that aside for a few minutes, and we're going to talk about first-party claims. And first-party claims are claims that the business would have against their own insurance company. And in the COVID-19 environment, these claims would be typically for business interruption losses. In other words, this pandemic has forced the businesses to close by virtue of government orders, typically state orders of closure, and they have suffered revenue losses. Now it's 4 months, and they are making a claim for a business interruption loss. These claims would be also, they should also include, when it comes to a restaurant, spoilage claims of food and perishables. So that is typically the claim. Now, having said that, I'm going to turn to a typical business policy, and I'm going to read certain exclusions that bear upon our exposure to this pandemic. There is what's called a business owner's policy. It's called a BOP, a business owner's policy. And the business owner's policy provides first-party coverage for the business, except there's an exclusion. And what does the exclusion say? It says, for any virus or bacteria. And I quote, any virus, bacterium, or other microorganism that induces or is capable of inducing physical distress, illness, or disease. If that is the cause of the business closure, then this exclusion would prevent, and I say prevent, and I'm going to come back to that word, would prevent and bar a claim for business interruption. There's also a document, which is an endorsement. I'm going to actually look at 3 endorsements on a typical business owner's policy. The first one says, exclusion of loss due to virus or bacteria. We will not pay for loss or damage caused by or resulting from any virus, bacterium, or other microorganism that induces or is capable of inducing physical distress, illness, or disease. This is a mirror image of what I just read you. Then there's another endorsement that says fungi or bacteria exclusion. It excludes coverage for fungi or bacteria. So here we are, and claims have been asserted throughout the country for business interruption losses by business. And the insurance companies, almost to a, it's like they stand shoulder to shoulder, and they are denying the business interruption claims because of the exclusions for bacteria and viruses. Now, 3 lawsuits have been initiated in New Jersey to counter the exclusion. And I'm going to go to the first lawsuit that was filed in New Jersey. It's in the federal court, the United States District Court for the District of New Jersey. It's a class action suit that was filed on May 5, 2020. And it's entitled the Benito Restaurant versus Chubb Indemnity Insurance Company of North America. And it's a 37-page complaint. And the first 10 pages recite the history of what has happened from Wuhan, China in January through the filing of this complaint, including the orders from Governor Murphy for closure of restaurants and bars and other businesses inside. And you'll remember the first couple months was there wasn't even service on sidewalks or and so forth. So now we're back 2 months ago, and this lawsuit has attempts to circumvent the bacteria and the virus exclusion. And how do they do that? They do that very clever, the way they do this. And they also recite the civil authority language, which says that if there's a civil authority, such as the governor, that closes a business, there's also coverage which is then taken away by the virus and the virus and bacteria exclusion. So what do they say here? On page 18 of this lawsuit, and you're going to find that this will be a template of thousands of lawsuits that will be filed at the federal and the state level. And they argue that this virus and bacteria exclusion does not apply, and that this restaurant and other class members are not bound by this exclusion, because what they say is that the losses were not caused by a, quote, virus, bacterium, or other microorganism that induces or is capable of producing physical distress, illness, or disease. Rather, the efficient and proximate cause of their business closure and their business interruption losses were because of precautionary measures taken by the state of New Jersey to prevent the COVID-19 proliferation in the future, not because coronavirus was found in or upon this restaurant's property. Very clever. And as I see it, this, I think, is a very cogent argument to avoid the exclusion for bacteria and virus. In other words, no one at the restaurant, in the kitchen, the servers, the customers, the premises, surface samples, no COVID-19 within this restaurant. So they argue, why should we close? Why should we be penalized and not be able to assert a business interruption claim when there's no COVID-19 in or about the restaurant? Very, very persuasive argument, as I see it. And to circle back to the way exclusions are interpreted, and keep in mind, it's narrowly interpreted against the insurance company and in favor of the policyholder. So therefore, if New Jersey has to pass upon this, they may very well say, well, this restaurant is correct. They're entitled to their business interruption losses because of what I just had articulated to you. And you should also know that New Jersey ranks in the top 5 states in the country that favor the consumer and favor the policyholder. And therefore, I can envision, even though I represent insurance companies, I can envision that this lawsuit and others would probably be successful, at least in New Jersey, to circumvent this exclusion. And I will now, that's where we are today. And that's where, because we can't undo history, we can't turn back the clock. Whatever the policies are that were written, everybody is bound by. The insurance company, the policyholder, and the court system. I was asked by one of my insurance companies, looking forward to draft an exclusion for them that would be, I hate to use the word bulletproof, but a clause, an exclusion that would serve to eliminate forever any such claims that are being presented now. So what I'd like to do is take the liberty of reading to you. And if you listen to the words I'm using, then you'll understand that I'm trying to capture every risk coming out of a virus or a bacteria event. And this document that I'm about to share with you is the product of 2 conference calls I had with local infectious disease physicians who assisted me in the medical language that I'm going to propose and that I've already sent off to several insurance companies who've asked me to assist them with their new policies. So here's what it says, and I apologize, it's 2.5 pages, but I apologize, but I think you'll understand from listening to this what we're trying to, the risks that we're trying to avoid. The insurance coverage provided in this insurance policy specifically excludes all damages or losses sustained by you resulting from 1, any virus, bacterium, parasite, pathogen, microorganism, or infection capable of inducing physical or emotional distress, illness, or disease, even if such is known or unknown at the inception of this insurance policy. And there I'm referring to this COVID-19 that nobody knew existed before these policies were written. And this exclusion applies whether or not this event is characterized as an epidemic or pandemic. whether or not transmitted by or through the air, water, human, animal, or any other living or deceased species, whether or not any of your damages and losses are caused or contributed to by bioterrorism, whether or not your damages or losses arise from any civil authority. And then I define damages and losses so as to make sure that we have our arms around every conceivable claim. So I define damages and losses to include, but not be limited to, any temporary or permanent physical, emotional, or mental ailment or condition to the person, any temporary or permanent business or personal revenue or profit losses, any temporary or permanent physical damage sustained to your personal or real property, interior or exterior, including contamination, any temporary or permanent computer or electronic data damages or losses, any temporary or permanent equipment breakdown damages or losses, or any temporary or permanent spoilage of product. And lastly, this exclusion applies to any business disruption caused directly or indirectly by the presence or potential presence of any known or previously unknown virus or bacterium defined above, and under no circumstances is a virus, bacterium, parasite, microorganism, or infection to be considered a, quote, covered cause of loss. And that's magic language, covered cause of loss, directly or indirectly, proximately or remotely. So if you compare this language to the exclusion language, which was like 3 sentences that exist in policies today, you can see where the insurance companies are going to be vulnerable, especially in New Jersey, to business interruption claims. As accountants, if a client comes to you and has these issues, your first resource should be go to the agent or broker who wrote the policy. If they get a letter of denial from the insurance company for their business loss claims, there's an appeal language in the letter, so you can file an appeal with the insurance company, and then if that doesn't satisfy your client, you go to the Department of Insurance. The last resort would be to resort to litigation, which can be expensive, but many of the policies provide, and the law provides, for the return of your legal fees in a lawsuit against your client's own insurance company for coverage where they have denied coverage. So I anticipate that I've covered the field when it comes to insurance company issues and exclusions and COVID-19. And my time is now there. So if there are any questions, I'd like to field them now. And we'll try to do this on the virtual platform that we're using. I'm not sure how they're being submitted. Maybe Donna can help me. Do we know whether any questions are coming in, Donna?
Hi, Lou. This is Ariana. We don't have any questions for your presentation.
Okay.
Thank you.
Thank you for your attendance. And on behalf of Cooper Levenson, we appreciate your participating in this virtual seminar.
Thank you, Lou. This is Rob Salad. Welcome, everybody, again. Lou, one question I have from a practical perspective, and that is, at what point should an insured place their insurance carrier on notice, and what are, if any, the applicable statute of limitations that may be involved in these claims?
Rob, the policies themselves provide for certain time limitations with respect to notice of claim. Usually it's within 72 hours of when the insured knows or has reason to know of they're having a claim. And then there's usually a fallback time in the policies that provide for a longer period of time for them to do that. The statute of limitations legally for claims against your insurance companies is 6 years, but you're bound by those notice provisions. Having said that, if you are not in compliance with the notice provisions, the burden then shifts to the insurance company to show why they were prejudiced by late notice.
So Lou, is it your advice in general at this point for insureds to at least place prophylactically the carriers on notice of a potential claim?
Absolutely. As soon as they know or have reason to know, and it should be in writing. And it should be by email and certified mail, and a copy should go to their broker and agent.
And obviously, if anybody has any questions on this call or your clients do, certainly Lou would be a valuable resource to assist in that endeavor.
Thank you, Rob.
Thank you, Lou. Much appreciated as always. So we're going to turn now to, I guess, the topic du jour over the last 4 months, which is the Paycheck Protection Program, which was enacted by Congress at the beginning of this pandemic to assist businesses and really to assist employees as well, because through the act, as Jared will explain in a few minutes, employers maintain employees on their payroll, as well as pay rents and benefits and other expenses. And this has been obviously a very organic process, changing from week to week to week. We have been tracking this from the start. Jared Stiles has been tracking this from the very, very beginning. It's been a very challenging road, to be sure, for all of us. And I know that you out there as accountants have fielded these calls, as have we, starting with, well, this was going to be an 8-week platform, and then it was going to be a 24-week platform, and now it's going to be anywhere from an 8 to a 24-week platform. The forms that were originally promulgated for forgiveness were then revoked, and at first seasonal businesses really weren't going to be very much assisted. Then they were going to be assisted much more, and now it landed in the middle. So, and we're not done yet with the program because the program was just extended for another month from now. But suffice it to say, we have several hundred clients in the program that we've been counseling all along, and the lead dog on our end has been Jared Stiles, who has been in this literally from the time that the legislation was proposed right through now. So Jared is going to tell us everything we need to know about the Paycheck Protection Program, sliced into a half-hour presentation. And so Jared, I'll turn it over to you.
Thanks for the kind introduction, Rob. So the first thing that I want to emphasize is that everything that we are doing is ostensibly built on sand that can be changed at any time. We've seen day-to-day changes through the program, through legislation, through guidance, through facts, and through interim rules promulgated by the SBA. We have also seen several lawsuits filed, which have changed the businesses that are eligible and ineligible through SBA rules and otherwise. Most notably, I believe that strip clubs in Detroit were able to engage in the program while they originally were not able to. One of the most recent changes, which occurred on or about June 26th, was allowing fishermen to be included in one lump sum, even though they were 1099 employees, which is a boon to them and their lobbying group. I'm going to give a brief overview of the entire program in its totality, explain the history of the program, explain some of the changes, because again, if you do not keep up with this day to day, you're going to have dramatically different outcomes Again, this is an overview. This is by no means comprehensive. I am happy to discuss questions, and I'm going to reserve time at the end of the program to address them. But let's take a brief overview, 10,000 feet above the ground view of exactly what has transpired and how we got here. So the CARES Act was very generous. And I want to emphasize that the Paycheck Protection Program is one of, if not the most generous programs in American history. Everyone who is applying and taking advantage of it, if they make over $150,000 in terms of their loan, which is convertible into a grant, is going to be subject, based on FOIA, to have a disclosure written about them in a very large Excel file that it takes me 20 minutes to load on my computer. Again, several large institutions are being outed. And again, depending on your level of outrage, this may or may not be good public policy. Originally, the administration was not going to release the names of the borrowers, but subsequently they decided to do so and have done so. Now, it does not tell the exact dollar figure that you have received, but what it will do is give you and the public an overview of a different tranche. For example, $5 to $10 million. If you get a loan under $150,000, you will not necessarily be named explicitly. Okay, so the original pot was $349 billion to fund the PPP. This ran out very quickly. You may have seen some headlines that Ruth Chris as well as Shake Shack received PPP funding. Now, I want to make it very clear that both entities were completely eligible to receive the PPP funding at the time that funding was made available. Furthermore, they returned the money voluntarily. There have been a lot of changes. One has been a return of funds on a voluntary basis. They extended the deadline several times. That time has come and gone. When we're talking about audit, which is going to be a popular topic of conversation in the coming months, under the PPP, any business that receives over $2 million is already automatically subject to audit. Mnuchin has already declared that to be the case. That's why it's very important, in my opinion, to document the underlying reason that you need the loan, make sure that you document where the loan proceeds go, specifically in regards to payroll. Again, the overarching purpose of the Paycheck Protection Program is to keep employees employed. Now, whenever you're going to push out legislation that is this robust, there are going to be numerous holes and unintended consequences. They have been doing their best to patch these holes and make certain that you are able to use the funds as they originally intended. However, that is not always the case, as we're going to see. Now, when you're doing your calculation for PPP, you are doing it based upon your overarching payroll. You would think that that would be easy to ascertain. However, that in and of itself has become an art form. Certain costs are includable, such as fringe benefits, such as retirement contributions made on behalf of the employer to the employee, health insurance premiums paid by the employer, and employee salary prorated up to $100,000. Now, these fringe benefits are able to be used to calculate, for example, assume a CEO is making $100,000 and the company has made a $20,000 contribution to his retirement. For purposes of the program, we'll be using $120,000, even though his cap is $100,000. Now that's in cash compensation. Very, very tricky. And depending on choice of entity, we're going to be seeing certain distributions that we're able to recapture and be used for the calculation. And for example, with S Corps, you're not allowed to use distributions. So we're going to see a lot of different outcomes. Again, it's a very fact and circumstance intensive test. And when we're talking about that, let's look at additional eligibility and the time frame that we have to spend the money. Okay. When we look at businesses that can apply for the PPP, we are typically, although not exclusively, looking at businesses that employ less than 500 people. Now, originally, there was a thought that they were talking about full-time equivalents. Additional guidance has come out and said it doesn't matter if you have X number of full-time equivalents. We're looking at both full-time and part-time employees for the cap. So that's very important. In addition to that, there are a couple of exceptions. And as always, the exceptions are as important as the rule. The SBA has their own internal size guidelines, which would allow certain businesses to employ up to 1,000 employees, for example. It is based on the NAICS number, which is going to be each business registers for it. It's a voluntary compliance program, as well as different restaurants and franchises. There are exclusions. For example, and I'm just using this as an example, I'm not saying this is a specific entity. Assume that I own a McDonald's franchise. I could, in theory, make application. Even though McDonald's obviously has millions of employees, if you look at it cumulatively, because each individual restaurant is looked at, I would have under that threshold. Now, the affiliation rules are important because depending on if you have multiple businesses, you cannot exceed a $10 million cap, and you cannot exceed 500 employees unless you fall into one of those special NAICS categories. All right. Now, one of the more complicated areas in this, both from an unemployment perspective as well as an application perspective, is what happens if I receive a 1099. What do I use? Well, if you are an independent contractor or self-employed, you are going to need to use a Schedule C to determine how much you are eligible to apply for. Again, we are able to use certain additional items to add in to determine what you are eligible for, but that's just on the loan amount at an initial matter. In forgiveness, there are special rules for these independent contractors, sole proprietors, and self-employed individuals that caps them at approximately, I believe it's $20,834 or $833, which is 2.5 months payroll. Now, if you are an employee, that number is over $46,000. Again, these things are written in sand. That's the current guidance as is now. It has not been done by statute, but it's certainly in the underlying forgiveness forms and applications, the reason of which, at least as espoused by the Treasury Department, is that at maximum they're looking to pay people 2.5 months. Now, there are ways around this because, again, we have a 60-40 split. 60% of your PPP loan must be used to pay for payroll costs. And again, payroll costs are pretty robust. We'll get into that in a little bit. But it's more than just what you think of when you think of payroll costs. Now, explicitly excluded from payroll costs are FICA taxes, which is kind of surprising, but state and local taxes are included in your payroll calculation. Obviously, FICA is a very large expense and burden, but it's explicitly excluded by statute. All right. So when we're talking about a 60-40 split, the 40% that you're able to use is for your rent and utilities. Now, when we're talking about, assume that you own a piece of property that you are on, you are allowed, to write off, you're allowed to use the PPP funding to pay the interest on the underlying loan. You are not able to use it to pay for any of the principal. You're also not allowed to pay ahead. So for example, assume that I am up to date on rent and I have paid rent religiously before I receive my PPP loan. I cannot then use my loan to prepay rent that is not during the covered period. The covered period is the 24 weeks after you receive your PPP funding. Utilities are more than what you think. For example, transportation is included in utilities. Cell phones, internet service. It's listed explicitly in the statute what is and is not a utility. And there are certain aggressive views that can be taken. Over the course of this program, we're going to explain a few of them, not the least of which is the ability to use leases of certain property. Okay, now let's go and discuss the actual calculation. When we're looking at the actual calculation, we're really looking at up to 4 different time periods. And I want to be very clear that when we're talking about this, the easiest way to do it from a practical perspective to look and see exactly what your client may be eligible for is to look at their 2019 940. The 940 is going to tell you the bulk of what is includable, but it by far does not tell a full tale as to what is and is not includable, because depending on choice of entity, you also have to include employers, partners, etc., that are not encompassed typically in that 940, especially if you are an LLC and you have distributions. So the reason I'm saying that there are 4 time periods is the initial time period is the calendar year 2019. You are also able to use April 1st, 2019 through March 31st of 2020. If that results in a higher number, I recommend everyone run it both ways. Both are perfectly allowable. Again, when we're looking at things, depending on the business's specific set of circumstances, we will typically run these all 4 ways, especially given our relationship to the shore community. I can see that a lot of people and a lot of our clients are using a seasonal method to calculate. Now, originally the seasonal method was not nearly as beneficial to people as it is now. And the reason for that is originally when we were talking about seasonal calculations, we were looking at between February 15th, 2019 and June 30th, 2020. That misses almost the entire summer. Due to lobbying and other reasons, they expanded that to include up to September 15th, 2019. You pick your 12 best weeks and we go from there. Again, these calculations include a lot of different things that are going to be specific to the businesses, and the guidance changes constantly on this. So I would make sure you stay up to date or refer them to someone who deals with this every day. Now, again, I'm going to jump ahead because we're running out of time, and I know that I want to take some questions, but the borrower must certify certain items. Specifically, that the loan is going to be necessary to support ongoing operations. Funds are going to be used to retain workers and maintain payroll costs. And in the event that the funds are used for an unauthorized purpose, such as, but not limited to, paying off other trade debt that's not allowable, using it as working capital to acquire additional property, again, these funds are very narrowly curtailed and fit into a very specific box. Okay, now the reason that everyone loves the PPP and why it's such a cash bonanza is they are making every effort possible to make this completely forgivable. What does that mean? Are there going to be tax consequences? Am I going to be able to deduct this at the end of the year for payroll costs? a lot of these things are unsettled. Again, we believe that they're going to make certain certain legislative changes. Again, we anticipate they already would have, but again, these things are, as always, ongoing, as the Internal Revenue Service took a position that you're not able to deduct any of these as business costs because, again, the loan. But we're not paying for cancellation of debt income either on this. Again, the grant portion is made easier by the most recent revision to the PPP loan forgiveness. Again, they did not originally have the original application out until some borrowers had already exceeded the initial 8 weeks. Now, due to the Flexibility Act, we have 24 weeks to spend it. Based on the 24-week period, almost every borrower is going to be able to fully use their PPP funding strictly based on payroll. There are certain safe harbors as well as penalties if you do not rehire employees. But again, it's a fact and circumstance intensive test. One of the most common questions that we have had is what happens in the event that I have employees who refuse to come back to work? Well, there's a policy and procedure for that, which includes sending certain types of letters and offering them employment and documenting it. But again, they keep making this a little bit easier to fit in because, again, the policy goal here really is to keep these businesses solvent, especially in these distressed economic times. Okay, I have about 10 minutes left. Again, there are specific deductions in the event that you fail to maintain employees and you fail to maintain salary. There are a bunch of individual carve-outs here that I'm not really going to go into in much depth. And in the event you received an EIDL loan and grant, that EIDL loan and grant is much more favorable than the PPP, at least from use of funds. However, we can move things around. Again, that is deducted from your forgiveness amount up to the $10,000 that you can receive. All right. Based on previous presentations that I've given, I would like to open it up to questions. I am more than happy to discuss this individually after this presentation. Again, there's a lot to take in here. I just want to make sure that I am able to address as many questions as possible. Again, I would, caution everyone that what we're doing is a constantly evolving beast. Answers that are good today may not be good tomorrow. And I'm going to be talking in broad generalities because every fact and circumstance is specific. One last topic that I did not include, but is important to note, is the amendment process. After a loan is locked, there is very little to do that you can do to change the loan amount, even if you would otherwise have been eligible for more money. There are certain things that can be done in certain circumstances. But again, after a 50-12 is issued, and that means the bank is paid for their underlying loan, the loan is locked and cannot be changed. This program was extended to August 8th. I recommend everyone who has any clients, seasonal or not, that has not engaged in this program, seriously take a look at it, because this is the biggest cash giveaway in American history. You, your clients, and myself will all be paying for this for the rest of our lifetime. But Congress feels that it is necessary to keep businesses afloat, especially considering that several of these industries are completely shut down, the hardest hit being the transportation industries, as buses are not frequently taken. Okay, quick time for questions. I'll be able to address 3 to 5. I will go very quickly.
Garrett, it's Rob. I think one of the biggest issues I've seen over the past month since the forgiveness process started, and mostly from the accountants and from the banks, is the timing of the forgiveness, because it's unsettled and unclear, since we've never seen this before, when this loan on the balance sheet of the participant in the program becomes no longer a loan. And so the concerns that I have heard from both accountants and from banks and from clients would be, well, I've used all the money up, so I'm done. But technically, I don't believe that at that point the loan would be deemed to be forgiven for any purpose, banking purposes, PPP purposes, or gap purposes. Then the second argument, I suppose, is, well, now I've made application for forgiveness, and shouldn't that be enough? And I'm not sure about that, and I certainly want, you and I have talked about it before. And then finally, yes, I've submitted and I've received something back from the bank, who's now gotten their money back from the SBA. Is that enough? Or is it after an audit, especially those clients and those participants that have received over $2 million who are automatically getting audited? And I believe that there's a 6-year period of audit. So I don't think there's any clarity out there, but I would like you to address the issue because it's imperative. And as we go through covenant testing for many of our clients and bank compliance issues, I think what we're seeing is we, on behalf of clients, are asking for some relaxation of covenants, especially when it comes to leverage covenants, where these amounts that were received by the participants are at some point deemed to be loans, and hopefully at some point won't be.
Yeah, so Rob, it's a point that's going to be well taken. As you mentioned early in the process of this presentation, we were looking at 8 or 24-week periods to determine whether or not we had sufficiently met tests. Additional guidance came out, so you can make an application at any time for the forgiveness. That's very important. Again, there is no definitive clarity on this. Each bank is doing their own individual internal look at these on when they look at it on a balance sheet. There is no clarity on it. Again, most banks are relaxing their standards, but again, you're going to have to look at the bank. I would certainly state that after you make application for forgiveness and you've received something back, that you have a defensible position, that there's a presumption that this is going to be forgiven, absent anything else. But again, there's no actual guidance, and it's going to be determined based on your individual bank. We have entered into special agreements with certain banks depending on the debt covenants to make sure that we do not go over. The audit on these lasts up to 6 years. So even if you get the initial forgiveness, that doesn't mean that you are no longer subject to audit, especially on these loans that are going to be presumed to be forgiven on good faith because they are under a certain dollar threshold. There are proposals in Congress right now to automatically forgive without any paperwork loans under $150,000. There's even been talk up to $250,000 as that would dispense with almost all loans. Again, that has not been passed. Guidance hasn't been issued, but this is a constantly evolving beast. I would state that you need to speak with your accountant, and your accountant needs, or your attorney, and you would have to speak with the bank to see when they would deem it to be off balance sheet. But because there is a presumption that they are going to forgive this, I would say that you would have a defensible position in the event that you receive something from the bank where they said that they have submitted it to SBA and that we would just anticipate they would be processing it within 90 days. Of course, with EIDL loans, we were supposed to be seeing the $10,000 grants go in within 3 days, and it took 2 months. So the actual processing time on this is going to vary greatly, especially as people rush to get these in. I anticipate that a lot of people are going to wait closer to the 24 weeks as opposed to the 8 weeks, even if they're eligible to file for the 8 weeks, simply on the basis that there's less to audit in the event that we go 24 weeks, as again, the program was originally meant to pay for 2 months or 8 weeks of payroll.
Thank you. I think that the rub here is the timing. And that is from the accountant's end, and all of you out there know it, that prepare financial statements. It seems to me that the safest way to go about our business is to keep the loan on the books until it's formally forgiven, with, however, a letter perhaps to the applicable lender that the loan is in the process, application's been made for forgiveness, and leave it to the individual bank. And I'm talking about not necessarily the PPP bank, but I'm talking about the lender, the normal lender for that particular business, which may not be the PPP lender at all. Because the problem that we have, that I've run into, with no specific answers of any uniformity from accountants, is when should this loan be forgiven for GAAP purposes and for financial reporting purposes? And that may be a very big deal, because the mere presence of that loan on the balance sheet could cause a business the unintended consequence of blowing a covenant, particularly a leverage covenant. And I don't think that was ever anticipated, because these are unsecured loans. So, and I've spoken to many big accounting firms, and there simply is no uniformity. They don't know at this point when the loan should be removed from the balance sheet. The most conservative position, which seems absurd, is to wait until the audit process is done. But as you said, that could be 6 years from now. And that seems an absurd position. It probably, on the other extreme, would be equally as absurd to say, when the money has been used up for payroll, mostly payroll, 60% or more, and the rest, that at that point, all events have occurred, and therefore, from an accrual basis perspective and a GAAP basis, the loan should be forgiven. So I think it's somewhere in the middle, and probably somewhere in the middle, it most logically will be when you actually make application to the PPP lender, and the PPP lender gets something from SBA and Treasury saying, yeah, we got it, and here's your money, bank, because we deem the loan to be forgiven. Does that make sense from a practical end?
Yeah, I think it makes practical sense that that would be how it would be treated. I think the accrual basis is the safest way to look at this under most circumstances, specifically in the event that you have used the funds completely for payroll, subject to that $100,000 cap. All events would have occurred at that time. That's without us even looking at the rent and utilities and anything that could be questionable, although it's very explicitly stated. There's no doubt in my mind that if you use it for pure payroll over time, subject to the limitation, it's going to be completely forgiven. And I think that the accountants can take solace in that, because that is both the point of the program as well as how it's written. So even under the most conservative approach, I would think that that would qualify for forgiveness 100%. I don't know if you agree with that, but I think that the best practice, obviously, is you're going to have to speak with the bank that is holding anything that may have any debt covenants to seek clarification. I know there are certain waivers that have been put out by several banks without naming names, and it makes a lot of sense because this is an unprecedented time. We have never seen a grant program where a loan converts into a grant before. So I think best practice is to paper the file and to make sure that you are completely insulated as an attorney or as an accountant.
Yeah, one final point. I know Ariana has some questions that have been asked, but what we're doing in one loan right now, it's actually a new loan for an existing client is changing banks. And what we did, which I think is a pretty ingenious approach, would be that the forgiveness is a post-closing covenant, so that can be kicked down the lane almost indefinitely. So the lender says, we realize that you have this loan. We realize that on a balance sheet basis, it needs to be shown now, but at some point in the future, that loan will be forgiven. And if, as and when it does, then that covenant can be removed. But right now it's an ongoing covenant for some period of time, but it doesn't create a default.
I think that makes
Marianne, I'll turn it to you.
I have two questions from the audience. First, quickly, as to forgiveness, what about contracted employees for a C Corp, for example, 1099 CTO for software development?
So this is a complicated question. 1099s typically are not includable as employees for the purposes of the PPP. I'm not saying that's always going to be the case, because until the 26th, fishermen on a boat who were 1099 all had to apply individually. However, they have now allowed them to be included on the employer's books. Again, that's a final interim rule that was specific to fishermen because they treat it more as a joint venture. But typically, if you issue a 1099, they're not going to be includable in your PPP calculation.
Thanks. And our last question is, as to forgiveness, what if a CEO and other officers lower their salaries to extend life of C Corp after PPP is issued? In this example, salaries were lowered.
Can you repeat that? You petered out at the end.
Sure. As for forgiveness, what if a CEO and other officers lower their salaries to extend the life of a C Corp after PPP is issued? In this example, salaries were lowered.
Okay. So again, you can pay CEOs and other key employees up to $100,000. Even, let me make this very clear. Even if you exceed $100,000, let's assume I'm making $120,000 as the CEO and I have deferred comp and everything else. Again, it's the proration over the period. So as long as I am not an owner and I am just the CEO, and it's very important that we distinguish between ownership and executive level comp, I can make up to, over 24 weeks, $46,000, and it will all be forgiven. It's a little over $46,000. If I'm an owner CEO of the business, specifically of the C Corp, and again, there are a lot of questions here, because if I own any stock, does that mean that I am stepped down in a publicly traded company? Because a lot of people are going to have stock. Does that mean that I am limited to that $20,833? There's no clear answer. I would certainly say that you are, if you're a member and owner of a publicly traded company, I would say that the most conservative view would be that yes, you would be capped at that $20,833. But again, I want to make it very clear that even if I'm making in excess of $100,000, all that matters for PPP is I am capped at that when I'm doing my PPP calculation for forgiveness and otherwise. So hopefully that answers the question. You can certainly raise those salaries back up in the event that PPP is forgiven. I would paper it, but there's no negative consequence that's going to happen if you lower your salary. But if you're asking me if I can pay $100,000 over the 24, like $99,500 in the period, no, it's prorated. So even if I pay it in one lump sum during the forgiveness period, that amount of money is not going to be forgiven. Everything is prorated.
Ariana, were there any other questions? I don't think so, right?
That's all for questions from the audience.
Thank you. Thanks, Jared.
All right.
Much appreciated.
Yep, my pleasure.
So we're going to move from PPP over to employment side issues. We have been deluged over the past 4 months with inquiries from our business clients relating to COVID-related questions. In fact, Jared raised that early on in his presentation.
Hey, Bill, I just got done giving my presentation.
Whether or not,
it went well.
Employers can fire employees, et cetera, in the process of this. What if they don't want to come back to work because they're concerned with COVID-related issues? So with that, I'm going to turn it over to Amy Rudley, and Amy will address these issues.
Good morning, everyone. It's a little bit bizarre to appear via Zoom, as everyone else has mentioned, but I scrolled through to see who's here, and I see some familiar names. So I know there's some familiar faces out there. And as Rob indicated and Jared alluded to, definitely we have had an interesting few months in the employment law world. And what we're doing right now is, I like to think, attempting to avoid what's going to come down the road for us in about 2 years, which would be litigation as a result of the decisions that we're making now. And so we are trying to guide the employers with feedback from both the state and federal government regarding what do they want employers to do in these situations and what do they want us to be telling them. And so that has been a challenge. And it was interesting to hear in a different area of law for Jared, which I wasn't quite as aware, that it's daily changing for them as well. And I've experienced that in the employment law arena. And just as, before I get into the meat of it, just as a brief example, last week on Thursday, so the day before the holiday, I had a question from a government client, a municipality, regarding this new travel advisory. And so what do they do with employees who think they're going to be traveling right now to these affected states? And I'll talk about this as it relates to your businesses and your clients' businesses in a few minutes. But for this governmental entity, the question was, can we put a policy in place? And the rules are a little bit different for them than they are for you as private employers. So I put together a policy in place, and I did this Thursday night so that they could put it in place before the weekend. And then come last night, the governor's office issued new guidance for municipalities and changed all of the rules. So the policy that we put in place on Thursday night already needs to be changed now as of the following week. So day by day, we are navigating through this and making the changes, making the decisions as we can. But it's not easy, and it's not easy as employers, and I certainly understand that. So getting through, my topic is getting back to business, and then frequently asked questions. I decided to do it sort of a who, what, where, and when, keeping it as simple as possible. And so I might not be that great about saying next slide. Okay, so who is the first? Who do you decide to bring back first? And this is something that I think could be fraught with potential discrimination or retaliation issues. So can we have the next slide, please? And I'll go through some of my concerns, which are the assumptions that some employers are already making and that I see in the questions that I have been receiving. So be careful with your decisions as to who you are allowing to come back. So with that, who you're allowing to come back, I'm assuming kind of an office setting. And so it's not who needs to come back. You know, I'm not talking about public safety employees or someone who's the security personnel in your building. I'm talking about you have an office full of accountants, but you can't off it. Who's coming back first? And so similar to making layoff decisions, be careful when you're making the decisions opposite of that. So who's going to come back? I put some potential considerations over on the right side here, maybe seniority, desire to return, availability, which involves some discussions with your employees, productivity to the extent that you can measure that. I know in some circumstances, like lawyers, we're easily able to measure productivity, whether it be by hours or by dollars. But for some businesses, that's a little bit more difficult to measure. Skill set, so some people can do lots of things and some people are, you know, a one-trick pony. Do you bring back the people who can do and handle a lot of things at the same time? And then other considerations that you might have based on the nature of your business. My concern here is that employers are going to fall into the trap of saying things like, well, maybe an older employee might not want to come back right now. They're enjoying their time at home. They're maybe kind of working their way into retirement, and everybody assumes this is going to be the next step before retirement. Also might be assuming that they're concerned about contracting the virus because of what we've heard in that the impact on older individuals. There might be an assumption that men versus women want to stay home or want to come back to work. And this is where it's going to get very tricky. And I encourage all employers to really take a quick self-assessment of the assumptions that you're making when you are making these decisions, because the discrimination litigation and maybe medical leave retaliation. These are things that can see coming back to bite us in 2 years when the statute of limitations, and the 2-year reference might not make sense when you're not living in the litigation world. So what I mean there is that most of the time, these employment cases are being filed right at the statute of limitations. And I imagine that has something to do with the nature of plaintiff's practices. What we then see is if something happens now, you get the lawsuit in about 2 years. So we're predicting for future. Now, my concern about the discriminatory decisions is kind of a double-edged sword, because what we are seeing is that the assumptions that you're making might be right on, but that's not an assumption for you to make. So when I tell you to have the conversation with the employees about who wants to come back in terms of prioritizing, unless you're doing it by seniority or productivity, if you're discussing a desire to return, you might find that your assumptions were exactly right. But that is a conversation you still need to have and document, and I'll talk about that in a few minutes. Could I please have the next slide? So the next issue is when, and this is kind of an easy one for employers, or at least it should be, which is when do you bring people back on your work site for your workplace? And that really depends on the nature of your business. And I trust that you've been able to figure out whether or not you're compliant with the current executive orders as they apply to you and your type of business. I know that there is some confusion among the state because I belong to this group of lawyer moms. So although it sounds very specific, there's 12,000 of us, and the fighting amongst some of these women with their firms, even in New Jersey, about whether or not they're allowed to be forced back to work before they're able because of childcare issues or otherwise. And some of us have the guidance from the governor's office at our fingertips and can say, here's what you need. And that's because we do employment law. And some of them are being told you must be back right away. So even there are law firms in the state who seem to have some confusion about this, and I imagine that they're not employment law firms. Make sure you're cleared to require your employees to return to work. And if they do push back, double check and make sure that at this point, it's not you can open and allow your employees to come back to work, but that you're allowed to force them back to work. And so for an accounting firm, it's a little nuanced at this point. You could have requirements to have some people back into work, but if you had someone who right now is productive at home, who has some sort of concerns regarding the virus, and we'll talk about that in a minute, there are some statutes that we need to navigate through, make sure they're not covered, and you have to make a decision as to whether you want to take a hard line as soon as you're able to have everyone back. Do you want to have everyone back? And switching screens so I can see my notes. So forgive me. It's yes. May I have the next slide, please? Thank you. All right. So for the executive orders, and this is my next 3 slides. So if we could just flip right through them, because I don't plan on reading them all to you. This is to show you all of the different changes that have taken place just during the period of time of this pandemic. And so as of right now, the state of New Jersey and the governor's office expects that our employers are familiar with whether or not they're permitted to open. And in addition to each of these executive orders, there is also guidance, daily guidance that's been issued. And I have the pleasure of serving on council in a small town in Gloucester County. And so I get a daily email in addition to these executive orders with some of the supplemental guidance that the governor's office is giving. And it's a chore just to read every single one of these executive orders as they come out, sometimes multiple a day, as well as the additional guidance. Of course, it's very helpful to my practice and in terms of managing the town, but I don't envy employers who don't do this as their day job. So employment law is my day job, and that's great that I can spend the time and learn this in order to help my clients. But for someone who's trying to manage a different type of business, this is a bear, and they are expecting that you understand as it applies to you. Can I please have the next slide? Thank you. So one simple thing is, what protections do you have in place? And so I just put the slide in here because I was doing the what, where, and when, and the who. And so this is an important one, of course, but I think it's one that doesn't really cover the employment law world, except when your employees start complaining that you don't have the protections in place. And so as far as giving employees the confidence that you have their interests in mind, I would, if you have not done so already, make some sort of notification to the employees of what you will be doing. And moving to the next slide, if you establish a written policy and then enforce it. So here's what we've done to protect you in terms of increased sanitation throughout the building, increased washing stations, hand sanitizer, whatever it is. Someone's going to be polishing the button on the elevator, or we're limiting people to a certain number of individuals in the elevator. And I'm not worried about what your policies are as much as that you have one and then you enforce it. And my concerns are less about managing the day-to-day of what you're actually doing in your office, as opposed to 2 years from now, I'm going to need a piece of paper in order to show a judge and a jury what you were doing. And so when your employee says they were victimized in some way, we're going to need a paper trail of how you were taking their health and their safety seriously and what you did and the enforcement of it. What I've seen so far with some employers is that they establish these written policies and then they don't enforce them. And that's become an issue. So some of the calls that I've been getting are, well, we have this mask policy, everyone has to wear masks, and then only some of the people are wearing masks. So they're applying it. It depends on the class of employee, or some people do not think the rules apply to them. And that's going to get employers into hot water as time goes on. So really strictly stick with whatever you put in writing. Sometimes you might have heard me say before, be careful what you put in writing, because employers are so quick to make rules for themselves, and then it gets used as a sword against you when you thought it was going to be your shield. And that's because they don't comply with their own policies. So if you put it in writing, then you're going to have to stick with it. Next slide, please. Okay, how will you bring your employees back? So this is where the meat of the questions that we've been getting have come from. And so what we're dealing with here is those employees who do not want to return or cannot return to your workplace. And we're seeing that for a few different reasons. We can move on to the next slide. Okay, so what are the reasons that employees are not interested in returning to work right now? The easy one is some of them are making more money on unemployment. And that is, of course, as a result of the $600, I'll call it a bonus, but the $600 additional money that they're getting during this period of time, slated to run out at the end of July, but we'll see if it gets extended. There's been some talk that it will be. And I'm going to talk about them in a moment, but they're afraid to return to work, just a general fear, no health concern, just I'm not ready. Also, those who are caring for children, daycare, summer camps been canceled. Those who are at an increased risk of exposure, live with someone who's at an increased risk, someone under a quarantine recommendation, or et cetera, someone who's actively ill. And so can we move to the next slide, please? All right, so why have they refused? And making more money on unemployment, this is certainly not a reason to return to work. And I'm laughing because it shows the creativity of employees, which is a sad part of my job, but it shows the human spirit of taking advantage of situations, which I find kind of amusing. So they have figured out, a lot of employees have figured out how generous all of these policies have been and all of these programs. And as Jared mentioned before, we are going to be paying for these for years to come. Currently, right now, we have a young woman who babysits for us from time to time, and her unemployment, her general unemployment from her young person job is $222 a week. But with that $600 a week bonus, she is living, I think, I'll spare you the words that her mom told me that she's living, but she's living the life these days. And the question this week was, should she sign for this new fancy car that she wants to buy? Because suddenly her income is just leaps and bounds over what it's ever been. So if she were called back to work and she were to say, no way, this is a life that I'm enjoying, what would happen? Well, assuming her employer would fill out the paperwork properly and isn't in cahoots with her, then you would lose your unemployment because then work does become available, and so the unemployment would stop. If they misrepresent the unemployment, and this is one concern, and if any of you did it, know that I'm watching you. I saw actually a lot of accountants giving Facebook employment law advice, which always makes me really nervous. And that one of them was, there's no harm in applying for unemployment as they expand all of these programs. Just apply, you might get approved. Well, actually, I think there is a harm. Sometimes you get approved and then the state changes their mind and you owe that money back. And so, well, sure, apply if you're entitled, but if it's a question, I wouldn't be so quick to say absolutely apply and there's no downside. There could be a downside. If you misrepresent the unemployment, or if it was a close call and they call it wrong and think better of it at some sort of audit down the line, they do come after people. May I please have the next slide? If an employee just has a general fear of returning to work, and so I'm not talking about someone who has a mental health issue going on, but someone who is just really scared and not emotional distress or PTSD or something like that. This is not a sufficient reason to fail to return to work. If there's no medical documentation and you have no reason to suspect some sort of disabilities at play, and you've assured them that the proper PPE is in place, they need to get back into the office. And then next slide, please. Okay, if they refuse, and at this point, I'm going to do something that I don't think that everyone anticipated I would do, and ask if I can screen share. This will stop other screen sharing. Oh, maybe I can't. So what I'll do then is I'm going to tell you the website. If you go to nj.gov/labor, and then you click through to the COVID scenarios and benefits available, you'll see that there's this great table, essentially, where they've told you about paid sick time and all of the different options. So if you have someone who's refusing to return to work and they have some sort of documented reason, maybe it's because they are under a quarantine order or started to speak about the travel advisory, and then we need to be going through these different processes and through these different statutes to see, are they covered by one of these? And if they are not, so an example of someone who's just not covered by any other reason, just like I was speaking of, someone who is just afraid and doesn't want to return to work, we're going to be documenting, and if it gets to the point where we need to be terminating, unfortunately, that is an option here. And may I have the next slide, please? Thank you. Okay, so the various relevant laws. I just listed them out here. Sometimes if you picture employment law, and this is how I picture it, as kind of in a movie where there's the creepy older expert on everything, and there's all the big volumes of books. That is what employment law has come to at this time during, generally it's a little bit like that, but with all of these additional statutes and these emergency statutes, it's become even more so because the questions aren't as quick as they usually are. So if you asked me in December a question about the ADA or the New Jersey FLA, easy, I can answer those questions all the time. If you ask right now about the interplay between the Families First Coronavirus Response Act and the paid sick leave and how it relates to these travel advisories, we're going to have to break it down to the individual situation, then when the notice was given, and each of these overlaps of these laws, which do overlap quite a bit. Could I have the next screen, please? Okay, so as far as what employers should do, first make sure you have all of your necessary PPE, communicate with your employees about what your expectations are of them and what their concerns are. If someone does have some sort of medical documented reason to be staying home, that's where we're going to be looking at these different statutes and offerings available to them. If you go to the New Jersey Department of Labor website, which in my opinion, they don't often update in years past. Until now, they update it every darn day. And so what you'll see on one of the first landing pages is bolded language that says whenever possible, if an employee is not able to work because of the COVID-19 virus, please continue to pay them. And then the state's trying to put into process some sort of protection like those Jared's speaking of, as well as all these other federal offerings under the CARES Act and then on the state level for employers to continue to pay employees or to find or work with their employees to find federal payment for them or state payment for them. And so that is where I think that it's most difficult to navigate. And I wish I could wave a magic wand and answer those questions for you generally, but I can't, because they're going to be depending on what that person's medical situation is, what their home situation is. Do they have children who've been displaced because of the pandemic, et cetera? You should consider each request by your employees separately, but be consistent when the circumstances are the same. So this isn't a time for, picking favorites, because picking favorites is really hard to explain as we get into litigation. And have your policy in place. And so sometimes, as I was saying before, the policies can come back to haunt you if you do not enforce them. But here's a time that it would be nice to have some guidelines to live and die by. And so I would recommend highly that you put them into place and stick with them. May I have the next slide, please? Oh, okay, that's my last one. I see that there is a question. Let me see if I can get it to pop up myself. Unemployment questionnaire. Is it okay if I just read the question myself? I know that's not how I did it before. Okay, super. So the question is, unemployment questionnaire states that if you refuse an offer of work because of concerns of COVID-19, you can answer the question, no, I have not refused an offer of work. How is a refusal to return impacted? It seems wording allows the employee to refuse work and still collect. So this is a somewhat recent change, and I want to switch screens so I can actually find how they explained it. Normally we have our normal, New Jersey unemployment assistance. And now we have 3 new ones: the pandemic unemployment assistance, pandemic unemployment compensation, and pandemic emergency unemployment compensation. So in reverse order, the unemployment emergency compensation is the one that's allowing people whose unemployment ran out to get an additional 13 weeks. The pandemic unemployment compensation is the one that's allowing them to get the extra $600 per week. The first one, pandemic unemployment assistance, is the one that is allowing for the coverage that you're asking the question about. And so for someone who has a concern, it's going to be fact specific, and that is going to be, it's going to take a while for the person to actually get an answer. I'm not sure that they're prepaying them before they make the decision, which would lead me to the concern that they could be asking for money back. But there are circumstances where if the state, in the state's mind, determines that the concern was valid in whatever way they're going to be defining that, they will grant unemployment under that first pandemic unemployment compensation. And so I have no way to know if that covers your question, but I hope it does. And if not, please feel free. How does New Jersey DOL know employee has had an offer of employment? So if you, I guess that could be asked 2 ways, and I'm not sure exactly which one you mean. If you are the employer who most recently employed that person and you're saying you can return to work and they're saying I'm not ready to return to work, there would be an employer portion of the unemployment application. And so that would be on the employer to communicate that to the Department of Labor when they're receiving the unemployment, I forget what they call them, but like follow-up communication from the Department of Labor to the employer. On the other hand, if it's someone who never worked for, I guess you wouldn't care if they never worked for you. But if it was a question because the employee is asking, then how would the Department of Labor know they had an offer of employment? They would just have to answer it honestly. Did they have an offer of employment? And you'd hope that they did. I don't know how else they would know. Okay, so see that's all for the questions on here. I know we got behind on the time before we got to me. So if there are no other questions, then I'm happy to say goodbye. Thank you.
Thanks, Amy, as always, very enlightening. And this is going to be ongoing. And I would suggest, Amy, that when either the unemployment special dollar figures are either elongated or not, maybe we can get a news alert out to the accountants and just to our general client base.
Absolutely. That's a great idea.
Because I
you, Rob.
suspect there'll be a significant motivation for folks to go back to work at that point. That may not exist as of
You would
right
think.
now. Yeah,
Sure.
good. Well, thank you. So we're going to turn now to Mike, who's going to deal with estate planning during this pandemic. Comes on the heels actually of a new client with whom I spoke yesterday, 85-year-old widow, whose opening response to me to questions of why now, her answer was, I never really thought about dying. I thought I was going to live forever. And now we're in the midst of this pandemic. If I get this virus, I'm dead. In the meantime, I don't want to burden my family. I need help. What if I get sick? What if I need banking? And so Mike's going to address issues just like that, which become particularly important during this period with general durable powers of attorney, do not resuscitate orders, physician orders for life-sustaining treatments. So Mike, I'll turn it over to you.
Thank you. I've probably never received more questions about this in my 10 years or so of practice than I have been recently. Just by way of a brief background, I know, it looks like I know most of the people that are on here. I work in the firm's estate planning and tax department, and day to day, I mostly work with individuals and small business owners, and it has been very interesting. For those that have not participated before or heard me speak, I generally like to start by what I am seeing on a day-to-day basis in my practice. And there's a couple of things that have come up in addition to estate planning that I wanted to highlight and bring to everybody's attention. I've received a lot of calls about waivers relating to the pandemic. I've prepared waivers for transportation companies that they're asking all of their customers to sign, limo companies and other livery operators to sign before they allow anyone to enter their vehicles. I've had a whole lot of landlords and people that are handling Airbnb people and similar types of occupants asking me to prepare waivers. These are tailored waivers that we have been preparing that are very specific to this specific situation that each person is handling. So I would caution you, for any of your clients that are small business owners or in the real estate world, particularly as landlords, to consider. I've also been involved in, as has Rob and several of us in the firm, in some real estate deals, mostly on the residential side, but a couple on the commercial side I'm handling right now as well. While there are specific laws now that, in particular in New Jersey, are applicable to landlords on the commercial side, they do not apply on the residential side. And I've now represented a couple of landlords, and I've represented now a couple of buyers and a couple of sellers during this pandemic that are either trying to enforce the contract and move forward with the sale, or they're trying to get out of the contract. And it has created very interesting issues that were very, very much heavily weighted on the specific language of that contract, namely the force majeure provisions. So if you have some clients that are bringing that issue to your attention, definitely take a look at the force majeure provisions, read the contracts carefully, as Lou was discussing with insurance. The same applies in the corporate and commercial transactional world as well. On somewhat of a humorous note, there is a case that came out of New Jersey, and it is become known as the bubble of pure air case. Don't know if any of you are familiar with this, but a New Jersey man a while back was getting frustrated with the poor air quality in New Jersey, and he decided to enclose he and his family in a bubble of pure air. He then claimed the costs in setting this up as a medical expense deduction, and he wrote pure bubble on his tax returns. He was audited by the IRS and they denied that deduction, but apparently the revenue officer was amused by the creativity of this taxpayer and decided to waive all of the penalties. But for those that are wondering, that is not going to be an option. If anybody wants to have clients that are or otherwise want to live in a bubble, it's not going to be a deduction. Next slide, please. So getting into the heart of it, there's 3 to 4 key documents that we often use in estate planning. I'm going to start with the power of attorney. In New Jersey, and I see we have participants from outside of New Jersey on here, so I apologize to them. I'm going to speak in somewhat general terms, but this is also fairly specific to New Jersey. The power of attorney will provide continuity of management of an individual's assets if they're unable to manage those assets themselves, whether they are no longer able to physically, mentally, or they just don't want to. They want to have someone else carry on their day-to-day financial affairs. The power of attorney allows that person to do so. One of the most common questions I am receiving these days is how to get that document signed. And that's going to be a common theme throughout this presentation is what are the requirements? In New Jersey, a power of attorney generally needs to be notarized, and it is, at least as a matter of best practices, should be notarized and signed by the individual who's creating that power of attorney in the presence of 2 witnesses and a notary. There is arguably a requirement of only 1 witness and potentially an argument that it doesn't need to be witnessed, but I don't think that is a matter of best practices. The notary can be handled remotely, and all attorneys in New Jersey are automatically notaries. So a notary could notarize the document remotely via video conference, but the witness requirement would still have to be in person. We're going to be discussing a couple of options and opportunities to work around that as I move forward. There's primarily, again, this is specific to New Jersey, a lot of other states do not allow it, but in New Jersey, there are primarily 2 types of powers of attorney that can be used in estate planning, while there are other types of powers of attorney out there, such as a limited power of attorney. In New Jersey, for estate planning purposes, a general durable power of attorney and a springing power of attorney are most commonly used. A general durable power of attorney will take effect immediately upon the creator signing the power of attorney. A springing power of attorney gets its name because it springs into effect only upon incapacity of the person who created the power of attorney. So that triggering event is often a source of confusion, and a lot of practitioners say, I hate using springing powers of attorney because now we have to meet the triggering event requirements. We have to go to a doctor or sometimes multiple doctors to gain the necessary written authorization from that medical professional that the person lacks capacity. I have not found it to be a very difficult process. You can often, in my documents, I write the doctor that is regularly seeing the patient can attest to the person's lack of capacity. I've seen them on a prescription pad. It is that simple. So I don't think that it's a very big deal, but it is something that's important. And for those that are appointing someone as their agent or attorney in fact, that is a spouse or someone that they trust very much, it is not a big deal usually to appoint a general durable power of attorney. But those that are appointing perhaps children that are younger, they may not want their children to have access immediately to all of their financial information, and they may wish to use a springing power of attorney. Next slide, please. The second core document of an estate plan is a living will. It has a lot of different names in different places in different states, often known as a healthcare directive or an advance directive. And it is a statement of your healthcare wishes. It should detail the preferred healthcare decisions, end of life decision making, and religious preferences that you have. It is prudent to provide a copy to a close family member. And that way, if the situation arises where a medical directive is needed, you will be able to quickly ensure that the person that you appoint or that a family member has access to the document. From a practical perspective, it is important that the hospital has a copy of this document on file as well. So for those of you who are local to our area, you say, you know, I know that I'm probably going to end up at Shore Memorial or I'm going to end up at Atlanticare. You may want to just notify both facilities and provide a copy of your living will to both medical facilities. It is important that if you move, that you notify the local medical facilities there. And if you update your living will, you should provide a copy. But it's really good to have a copy close by. It is also good that your next of kin, either a spouse or that your children or whomever takes care of you, has a copy of the living will so they know the express wishes that you have in these end-of-life decisions. If you are unmarried, it is prudent to name an unmarried partner of yours, if you do have a partner, as your agent, because if you do not do so, that person is not going to have any legal rights. They will, there's a priority list in descending order as to who's responsible for making end-of-life healthcare decisions upon your incapacity, and somebody like a partner who is not your spouse or domestic partner may not have any rights. So it may default to an adult child or your parent or an adult sibling to make those decisions. And if they can't find anyone and it's in an urgent matter, now somebody is going to be making those decisions that doesn't know you. Next slide, please. I've written articles over the years about the physician orders life-sustaining treatment process called a POLST order, a physician-prepared medical order. And it became in vogue probably about 5-6 years ago and is starting to become more and more popular. But there are certain issues that need to be addressed before you sign this document. So first, unlike an advanced directive that I just discussed, a POLST order does not appoint a surrogate or a person such as a medical proxy to make end-of-life decisions for you. It only provides specific medical orders for treatment in very specific instances during a medical emergency. It is more of a document that complements an advanced directive. If you lose decision-making capacity, the person named in your advanced directive will be able to void your POLST form as well, particularly if it's outdated and doesn't comply with the wishes in your living will. It is a document that must be completed by a healthcare professional. It is not completed by the patient, and it should be mostly prepared in the event of a life-threatening emergency or event. It should be drafted to specify medical orders rather than general wishes about your treatment. And it is important to maintain the original POLST order at the healthcare facility. There is now some software out there, and a lot of hospitals are starting to participate where they are sharing this information. So if you are on a trip in California and you are hospitalized and that hospital participates in this program or on the same software that Atlanticare, for instance, or Shore Memorial may participate in, they may be able to gain access to a POLST form or other directives. So you may want to ask those questions as to what options are out there. Next slide, please. One of the most common questions I've received, not just now, but over the years is, do I need a DNR order? And they're often misunderstood. A DNR order, a do not resuscitate order, will provide for the ability to prolong by means of resuscitation. It is not something that is universally accepted, and leaving that decision to healthcare providers can be precarious. In many states, a DNR order may be issued during hospitalization to take effect after hospitalization, or it may be issued for a person who is not a patient in a hospital. This was very controversial just in the last couple of months in New York, while it was the hotspot of the pandemic. And there were a lot of medical professionals who were seeing these DNRs, and they were in a very specific emergency and they didn't know what to do. And there is a law in New York that allows a healthcare professional to disregard the DNR order if they believe in good faith that consent has been revoked, or that the DNR has been canceled, or a family member or others that are on the scene when that medical provider is providing medical assistance objects to the DNR order, and there may be a confrontation. And this was creating a lot of issues. So I would be cautious with just simply using a DNR order. It is something that I would recommend you incorporate into a living will or advanced healthcare directive, as opposed to just a DNR order. And naming the healthcare agent or surrogate allows you to appoint the person to make those decisions, as opposed to a medical professional that does not know you. Next slide, please. From a practical perspective, again, a lot of clients are either taking care of elderly parents, or perhaps they're serving as a guardian, or they're a caretaker for someone, whether it's a child with special needs, or a parent, or a sibling, or somebody else. And what often happens is that a person who is being admitted to a healthcare facility will be accompanied by that person, whether it is someone that is informally taking care of them like a child, or it's a formal appointment of a guardian or a caretaker. And this is something that Jared and I see quite a bit. We have a elder care practice where we represent a lot of people who are either guardians or caretakers, and we assist in preparing Medicaid plans, and this comes up a lot. The person will have already been institutionalized in a healthcare facility and will request the documents that the person signed, the contract outlining all of the provisions governing that person's relationship with the healthcare facility. And we will see on these documents a line that says responsible party. And the responsible party is often misunderstood. The person thinks that they are just responsible for taking care of that person. And so they sign on that line and they don't read the fine print, and they don't read what is right above that in the contract that makes that person financially responsible for everything. That is a recipe for disaster for a number of reasons. That person who is perhaps a child or a sibling is now becoming personally responsible as a guarantor for all of the financial obligations. It is something that creates a lot of issues also with health insurance as well. So before you sign anything, before your clients sign anything, when they call you and say, mom or dad or my brother or my sister, whomever is going into an institution, going into a medical facility, it just be a routine hospitalization, just have some type of pains, and that person can't sign, and this person signs as responsible party, and now there's an issue with insurance or otherwise, that person that signed as a responsible party may have a significant problem. Again, from a practical perspective, take the time to gather and account for all the insurance information for that elderly parent or the person you are caring for. If there is supplemental insurance, make sure that you obtain that. Find out the list of healthcare facilities that are covered under the insurance plan. Make sure that you have everything organized. Make sure you have those living wills and powers of attorney lined up, and you understand that person's wishes, so that when that day comes, which it inevitably will, you are prepared from a practical perspective. Next slide, please. In terms of a will, drafting wills, it has, from a practical perspective, again, created a number of issues. In New Jersey, since a lot of you are New Jersey residents and have clients that are in New Jersey, the laws require 2 witnesses to sign a will, unless it is in the person's own handwriting, the testator, the person who creates the will. If it's in their own handwriting, called a holographic will, then the witness requirements are no longer needed. In order to be self-proving, then it has to be notarized. And the self-proving requirement means that the people who signed as witnesses after the person passes away are not going to have to come into court. They're not going to have to sign affidavits. They're not going to have to make appearances. It streamlines the process quite a bit if a will is self-proving. And so we always recommend that wills are self-proving. In New Jersey, Governor Murphy signed Bill A3903 into law a couple of months ago, which now allows estate planning documents, and particularly wills, to be signed in the presence of a notary remotely. So again, now we will not need a notary to be live and in person. They can do so via a video conference, but that law did not account for witnesses. So witnesses are still required to be in person, seeing the person sign. Over the last couple of months, we've done a lot of creative things. We've had people sign in their cars and the windows were up and the people could see them through the windows. We've had people sign in their houses and they had a window right near them and the people were able to stay outside. We have a plate glass up in a couple of our offices and we've had people sign on one end of the plate glass. As long as there is a direct stream of sight and you can see the person, a line of sight, then you can see the person, then that would be acceptable. One other option, and we're going to get to a trust. In fact, we can get to the trust slide now. We'll go to the next slide. With regard to revocable trusts, is that we have had some clients sign a will in their own handwriting called a pour-over will. And it simply states, I, testator Michael Salad, leave everything to my revocable trust created on even date herewith. And now the trust can govern the primary disposition of a person's assets. So while there is those two witnesses and the notary requirement to be self-proving for a will, that unless it is in their own handwriting, that is not the case for holographic wills. So we are now having someone just write one sentence in their own handwriting and sign it, saying they're leaving everything to their trust. And then the attorney, us, we can prepare the trust, and it is basically a will substitute. And it works really well because now the trust does not have witness and notary requirements like a will does. And in the event of Rob was just talking about that 85-year-old client, perhaps they get ill. If they have enough capacity and are able to have the strength to just write one sentence, we can then create the trust and they only need to sign it and we don't need to have a witness and notary requirement. So in general, we don't use revocable trusts all that much because it is mostly an instrument used to avoid probate. But because we are in unusual circumstances, we have been, at least I have been over the past couple of months, using this tool. And there are other benefits to a revocable trust. It provides privacy and it will avoid probate administration and streamlines the process. So it is a tool that I would recommend we contemplate as clients move forward during these unusual times. With that, I'm going to take any questions because I know we're starting to run low on time here. And I will wait to see if anybody has any.
Hey, Mike, we have a question
Okay,
from
it
the
looks like there is
audience.
one question here, if it's all right. Ariana, I'm going to just review it. It says, how do you avoid taking financial responsibility when a parent loved one goes into a facility? It's a good question. What I would recommend that you do is that if the person that you are bringing into the facility has capacity to sign, that person can sign. If you have power of attorney over that person, you may sign in your capacity as the agent or attorney in fact. You just need to sign with the words POA or power of attorney or agent or attorney in fact after your name. So if you sign as a responsible party with POA and then for the name of the person, you would be fine. If you take a person in, you don't have power of attorney, and that person does not have capacity, they can't refuse to provide medical assistance to you. And I would just tell you not to sign anything at that time. And then hopefully the person will regain capacity. They can either sign themselves, they can sign a power of attorney for you. But if until you have that, I would not sign as the responsible party. It's a good question. Thank you. Are there any follow-ups to that, either Margaret or anybody else? Okay, if there's nothing else, I will probably remain on afterward. You see all my contact information here. By all means, please feel free, call me, email me, or otherwise get in touch, and I'm more than happy to field any of your questions. Thank you.
Thanks, Mike. All right, I will clean up here, and we're going to move rapid fire to just touch in the next 5 or 7 minutes about recent developments that I thought would be of interest. The first was 2 weeks ago, June 24th, the service published Revenue Notice 20-51. That's up on your screen now. Pretty important. This provides guidance for taxpayers who received RMD's required minimum distributions in 2020, but now wish to return those payments and waive RMD requirements. Our clients and all taxpayers now have till August 31 of this year to repay the funds into their account. If you haven't done so already, I would recommend that you advise your clients who are in pay status on their retirement plans to consider this alternative. One unanticipated manifestation of the pandemic was the collection of e-commerce sales and use taxes. In most states, tax collections in general have decreased by 50% over since this pandemic started. But thanks to the Wayfair decision by the Supreme Court 2 years ago, all those states, and there's 48, that impose tax collection remittance requirements on remote sales are now increasing those revenues dramatically. In general, e-commerce sales have increased by 128%. That's through April. I'm certain that that number would have increased in May and now June. Moody's modeled out an estimate showing that sales tax collections will decrease 15%, 15% in 2020. More alarming is that it appears as if state sales tax collections are not going to go back to 2019 levels until 2024. So states are going to be faced with significant problems, not just this year and not just next year, but for the next 3 or 4 years. And as I indicated, online sales are way up. Walmart, for the first quarter of this year, and remember the pandemic only started in mid-March, for the first quarter, Walmart's online sales were up 74%. Again, I'm certain that that number is going to increase significantly in in this quarter, the second and third quarters of this year. Who's getting audited? What will surprise you is who's getting audited and who's not getting audited. Who is getting audited? There was a publication 3 weeks ago that said that private foundations are being audited more than any other taxpayers. The service said that over 1,000 private foundations are currently identified for audit. Who's not getting audited? High income taxpayers. So take us back to 2012. In 2012, 14.5% of taxpayers making over $10 million for the year 2012 were audited. In 2015, that was taxpayers making $10 million a year, 8.5% of them were audited. Right now, for the year 2018, which is the year of audit that's currently under the IRS's radar, 3 out of 10,000 taxpayers, so 0.03% are being audited. 0.05% of taxpayers making between $1 and $5 million are being audited. So the service simply before the pandemic didn't have the resources to carry on these audits, and now it's abundantly clear that those audits are being decreased at rapid levels. There are 10 million pieces of mail, either tax returns or that were filed by hand or correspondences sitting in trailers at IRS campuses that have been closed. The flip side of that, 20 million notices that were to have been sent out by either automated collection systems or some other branch of the service have not been sent. We believe that in the next month, many of those 20 million correspondences will be sent. So we'll all be busy fielding correspondences from the service, at least I would think, in the next couple of months. 2 weeks ago, the service announced that micro insurance companies, and I've dealt with those in the last couple of seminars with the audits, that they're still being targeted for enforcements, but letters to micro insurance companies have not been sent. The other area of specific target on a specific item would be land conservation transactions and easements. So those of our clients that have been involved with taking deductions for land conservation easements, very likely to get audited as a target area. Finally, just on a the truth being stranger than fiction note, I included in your materials the case of Peliovsky versus Commissioner. It was decided last week. It's up on your screen now. This is a tax court case, and it's really instructional as to what not to do in an audit and what not to do in a tax court proceeding. Mr. Peliovsky, the taxpayer, was employed as a senior database engineer by PIMCO, the Pacific Investment Management Company. And the taxpayer reported over $176,000 of income from PIMCO on a W-2. The taxpayer also reported $10,000 of gross income and $50,000 of expenses that were deducted from what the taxpayer claimed to be a Schedule C business. Unfortunately, the taxpayer was picked up for audit, and indeed the Schedule C activity appeared to be remarkably the same for what he was doing for PIMCO. And in fact, not only is it remarkably the same, the only customer he had was PIMCO. And so he billed PIMCO a separate amount of $10,000 and wrote off $50,000 as part of his return. At trial, he abandoned his position that he was an independent contractor and said, no, I'm an employee, and therefore some of the expenses that should have been written off as an employee were. The final blow to the taxpayer was that the taxpayer had no proof for his deductions. He deducted meals, entertainment, cars, trucks, travel supplies, didn't have any backup on that. And not surprisingly, the taxpayer lost. And I'm wondering if the taxpayer will now get referred to the Criminal Investigation Division because the case is an abomination. So you'll see the decision I put in front of you just for your reading amusement. With that, if there's any questions, happy to answer. It doesn't look like there are any, Ariana. I want to thank Ariana for assisting us both in terms of how this presentation was going to come down and also in terms of the technical end of it. We had a pregame on this earlier in the week, and thanks to Ariana, this presentation went a lot better than the pregame. So I really want to thank you, Ariana, for everything that you did in putting this on. It's not easy. I know there's pressure on you to get this done, but we're really thrilled. And also the timing of it, for those of you that participated, we appreciate the participation. We know that with the April 15th becoming July 15th deadline, it was very difficult for you to tune in. And we appreciate it and looking forward to seeing you in the fall. We hope in person, but if not, we'll do this again via Zoom. Thank you.
Sure. Thank you very much, Robert, and to all the attorneys and staff at Cooper Levenson for participating in today's program. Thanks to everyone who viewed today. Just to let you know, your credit letters will be issued within about a week of the conclusion of this presentation. If you have any questions, please email us at education@njcpa.org. At this time, I'll end the meeting. Fortunately, you'll be kicked off, so there's no little happy hour at the end of this. So thank you, everyone, for participating, and have a great day.